Hello, friends, and welcome to another WSIB Truth Matters with Joe Machado. I hope you're enjoying this beautiful Thursday afternoon. So I'm going to start a very exciting series for me. It's a subject that I've always enjoyed. I did a lot of research and used it often with my paralegal firm. And then you've also heard me refer to it in a number of videos that I've done. And that's the subject of tribunal jurisprudence. Essentially, what tribunal jurisprudence is, it's a body of decisions that the Workplace Safety and Insurance Appeals Tribunal put together on any number of issues that they were faced with, appeals for a variety of different types of benefits and entitlement to benefits under the Workplace Safety and Insurance Board. As most of you know, the Workplace Safety and Insurance Appeals Tribunal is an external agency that has the power to overrule WSIB decisions. And it is the last level of appeal when dealing with the Workplace Safety and Insurance Board. The reason why this has always been a very important subject for me is because I have no faith whatsoever in the WSIB's appeals branch. Over a period of 30 years of dealing with the WSIB, both as an injured worker, as well as having built the largest paralegal firm in Ontario with over 10,000 clients, dealing with them day in and day out at the operating level, the appeals branch, and just looking at the decisions and how they go about making decisions. It seems far too arbitrary than it should. And it doesn't really provide the worker, in my opinion, with the true level of justice that they deserve based on the law. And so when I started looking to the tribunal and looking at the various issues that they deal with, it helped me and my staff, other paralegals, to tailor to do research in the issues that we were presenting, to ensure that if there was tribunal jurisprudence with respect to that particular issue, that we would be able to tailor the case, look for the different factors that the tribunal would normally look for in those types of cases, to therefore strengthen the position and the argument for the client. Now, it's important to note, though, that every case is individual and that the circumstances of each case are often different as well. But when you have the tribunal, the last level of appeal, gathering a body of decisions that provide for a consensus in a particular area, then that's very helpful in a number of ways. And so I really wanted to illustrate for you what jurisprudence is and how it can benefit not only injured workers, but also others that are involved in this industry. So to best illustrate this, I'm going to talk about a document that was prepared for the Council of Canadian Administrative Tribunals and their conference in 2006, titled Jurisprudence and Consistency. And I've often referred to this document over the years to ensure that my practice is in alignment with those topics. So what's important in a jurisprudence or a body of law? So some of the key elements are, according to the Council for Canadian Administrative Tribunals, is that the decision is competently reason. So in other words, it is within the law. It's satisfied, or it satisfies the various sections of the law. In this case, it would be the Workplace Safety and Insurance Act or the Workers' Compensation Act 1997 as amended, and prior acts as well. Also, that the decision is well written and coherent so that the average person can read it and understand it and it makes sense. That's something that the WSIB strives to do. The other thing, too, is that it's readily accessible to both potential and actual parties in their counsel that are addressing a particular appeal, to academic researchers, to the public and the press, to each of the members of the tribunal, because they look to each other when making their own decisions to provide a sort of consistency that's balanced within the law, and also to the government that they have to report to. So there are 6 principles that they go by, and I'm going to put each one of them here on the screen so you can see, and we'll go through each one of them. It's important that you understand this, because this can be an immeasurable tool in helping you address whatever issues you may have with the WSIB. So the first one is that the principle that like cases should receive like treatment. So I'm going to put this up here on the screen here. It's one of the most fundamental principles of any liberal theory of justice. Indeed, some philosophers are of the view that it is the most fundamental principle, and without a jurisprudence, it's completely impossible for that principle to be respected. Without a jurisprudence, losing parties do not know and cannot find out if other parties with like cases, so similar cases, have received the same treatment. Moreover, the tribunal members themselves cannot find out if their planned decision in a particular case is in conformance with that principle, since they too cannot access the like cases which other colleagues have previously decided on. And without a jurisprudence, neither the tribunal's management nor the ministers to who the tribunal reports, which in this case would be the Minister of Labor, or the legislature, can know to what extent the like cases principle is being respected. So when talking about consistency and ensuring that everybody is being treated in the same way, and it should, so that justice is fair, this is one of those key principles. So the second one, I'm going to put it up on the screen here. And without a jurisprudence, the tribunal simply cannot be held accountable for the quality of its decision-making. Again, looking at the board, a lot of it seems arbitrary, and in a lot of cases, I don't see that they follow policy, their own policy, or the law in a consistent manner. Without jurisprudence, outside critics, the advocacy community, legislative council, the press, the host ministry staff, can only evaluate the tribunal's performance on decision, or one decision at a time, whereas it is the overall quality of the body of decisions and the relationship of each decision to the others that tells the tale as far as the tribunal's institutional performance is concerned. And that's very important. Again, going back to ensuring that there's a consistency among decision making, that appellants are being treated in a like manner, that it doesn't appear as though it's being arbitrary and based on a particular person's view as opposed to the implementation of the law. And so this second principle is very important. So I'm going to put up the third one now. And so this one states that without a jurisprudence, there's no possibility of the tribunal's understanding of its constituent statute involving in the common law manner over the course of a series of decisions dealing with related issues. In short, there's no possibility of achieving coherency in the tribunal's body of decisions. If it is not part of a jurisprudence, every decision becomes one-off event, except for whatever anecdotal knowledge of the decision that might come to the attention of another decision maker or parties. In other cases, in an informal and random way. Again, as you can see, this principle strives for consistency among the decision-making process. Number 4, the existence of a tribunal jurisprudence allows potential parties, and this is the one that I really and truly appreciate, allows potential parties to their counsel to evaluate the likelihood of success if they decide to take their case to the tribunal, and thus discourage applications that an examination of jurisprudence would show to be problematic. So in other words, if I'm acting on behalf of a client and I'm appealing a particular matter at the tribunal, and I'm doing my due diligence, doing my research, looking at jurisprudence within cases that are very similar to that of my client, then I could use that as a tool to put together an argument with a stronger case of success. But if I'm looking at tribunal jurisprudence and some of the key elements are missing or unavailable or cannot be obtained for my client, then success would be problematic. And that's where you have the opportunity to have a sit down with your client, explain the whole process, explain what you've done, what you've discovered, and then allow your client to make a decision based on good information as to whether or not he or she would like to continue with the case. The principle number 5, the jurisprudence allows parties and or their counsel who decide to apply to the tribunal to discover the issues they are likely to face and the law which the tribunal applies, and thus gives them fair opportunity to prepare an informed and intelligently focused and argued case. Again, brilliant. It can be an amazing tool. This in turn helps the tribunal panel to make an informed and intelligent decision. And believe me, tribunals, panel members, vice chairs, they appreciate this. They appreciate it when they have somebody who's knowledgeable in the law, knowledgeable about the case, and is presenting a case with merit that satisfies all or most, if not all, points in those that have been done, written in other decisions that make up that jurisprudence. And then lastly, without a jurisprudence, the courts are prevented on judicial review from considering a tribunal decision in the context provided by other tribunal decisions on related issues. The absence of a jurisprudence therefore undermines the court's chance of rendering a contextually sensible decision. So yes, friends, there is another step that you can go beyond the tribunal, and that is a judicial review. However, having that jurisprudence makes it that much easier to present a case, a compelling case, that could or would satisfy a judicial review, in my opinion. So, friends, it's a good series that's coming up, starting on Monday. I'm going to talk about Monday to Friday, I'm going to talk about 5 distinctive issues that have been addressed at the tribunal, where there's significant jurisprudence in each one of the individual cases that I'm going to talk about. It's an amazing tool. I urge you to have a look at each one of the videos of the series. I believe you're going to find something useful. And a lot of the principles that I've applied in my company, WSIBsettlements.com, follow these principles to help our members achieve success in their cases. So looking forward to that 5-part series. Friends, if you're not subscribed to my channel, I invite you to subscribe to the channel. It's free. Nobody's going to be looking for money. And so you get notified each time that I come out with a new video. So all you got to do is click the subscribe button, and please share my videos with others. There are thousands of injured workers in this province, from one end of the province to the other, that are looking for help, that need help with their WSIB claims, whether they have an ongoing case, whether they've had a previous case that didn't work out. People need help, and the WSIB is doing everything they can, in my opinion, to put up more and more barriers for injured workers and ill workers and their families to claim benefits. We cannot allow this to happen, and I'm going to do whatever I can with this channel to help as many people as I can in this province with their claims, to make sure that they're heard and that they're well supported in their claims. And so please share my videos and give me thumbs up. And if there's a particular subject that you would like me to talk about in one of my future videos, then send me an email at joemachado at WSIBsettlements.com. Let me know what it is, and I'll work it into one of my future videos. All right, friends. So once again, thank you for taking the time to listen. And as always, take care.